After there's a sex crime accusation, when someone gets wind that there's an accusation, what law enforcement is going to do is they are going to immediately go and speak with the victim, obviously, the alleged victim, and with any witnesses that that alleged victim points them to, because they're going to want to gather as much evidence as possible as quickly as possible. They're also going to want to speak to the person who's been accused of the sex crime. And, they're going to want to do that because they're going to want to get some sort of admission from the accused person that they were involved in the sexual encounter that occurred. A problem with that is that an accused person, especially one who doesn't think they did anything wrong, is going to make statements that that person thinks is helpful to them because they're innocent of a crime. Maybe perhaps it was a consensual encounter, and they say, no, it was a consensual encounter. I mean, we had consensual sex. There was nothing inappropriate about our contact. Well, now what they've done is they've admitted that they had a sexual encounter. Until the accused person did that, the law enforcement perhaps didn't have any evidence that there was, in fact, a sexual encounter other than what the alleged victim stated. So that person has now incriminated themselves. So what can be expected is that law enforcement is going to go out, they're going to do an investigation, they're going to try to get the accused person to incriminate themselves. And so that you really need to get an attorney on as quickly as possible. You need to not make any statements. You need to have the attorney contact law enforcement to see what the evidence is and see if there is actual probable cause to believe that there was a sex crime committed. A lot of people say, well, there was no evidence that the sex crime was committed. All they have is that person's word. Well, I'll give you an example of a time when a person's word is almost enough. All they need in addition to that is perhaps an apology by the accused person. An apology can be deemed an admission of guilt and an admission that they did something wrong, even if the person accused may be apologizing that that was the alleged victim's experience, but it wasn't actually what the accused thought had happened. The accused person thought that it was consensual and maybe is really upset by the fact that the alleged victim thinks that it wasn't consensual. And so there's the apology. So while in general, cases are not brought with one person saying something happened and another person saying something didn't happen, very little is needed to be added to that. For instance, the alleged victim could tell a best friend right after that there was a non-consensual sexual contact, and that may be deemed enough. Just it's called an outcry witness. That best friend can be deemed an outcry witness. So I would tell anyone who's accused of or believes that they're being accused of unlawful sexual contact, immediately contact an attorney. That's step one, okay, to protect yourself, to not get yourself into trouble by accident. Contact Kardon Law if you want to speak to an attorney who has about 34 years of experience in this area, both as a prosecutor and a defense attorney, to help you best have your rights asserted in a situation.